minutes. Minutes your lordship delivered
Yes.
Devesh Sharma on 11/8/2023. And minutes, my lords hope that it would put an end of all controversy with regard to B.Ed and D.El.Ed, etc. That has not happened, minutes. My lords, may kindly have a look at the chart, minutes. It only takes a minute. On the date when your lordship pronounced the judgment.
What is the effect of the judgment? It is held to be prospective.
Yes, minutes.
It means up to that date, they could participate.
Minutes. By that date, there was selection process going on when my lords indicated that judgment would be pronounced on 11/8. 11/8 it was pronounced at 10:30. Thereafter, they issue a selection list and totally 12,000 B.Ed candidates have been recruited. And minutes, the litigation ensued, and minutes, everywhere it's been said subject to the outcome. When a clarification is issued by your lordships, there one reference is there saying that one, if they got appointed subject to the outcome on an application filed by them. Since these candidates have not filed but somebody else filed and invited that order, so it doesn't apply to them is the reasoning of the Honorable High Court. But the same candidates have come before your lordships, they have sought protection, and my lords have said that yes, subject to the outcome of other proceedings. That's been ignored, and all that's been said is that since there is a clarification, they alone should have filed the application. That means two classes of people. If they have come to the court, they are disqualified. If they have not come to the court, they are qualified. My lords may kindly see there are 4 streams of appointments. The second one stands protected. None belongs to that one.
No, show the operative order of the prospective declaration.
Yes, minutes. Let's kindly come to the IA. Let's it starts at 104.
Yeah, is it?
Yes, minutes. Kindly come to 110 minutes.
Yes.
The last paragraph. As it appears that a large number of candidates with B.Ed degree had already been That's the relevant part. Well, let's go. As it appears that a large number of candidates with B.Ed degree had already been appointed on the basis of eligibility criteria specified by the education authorities, we do not be equitable to effect their removal. We accordingly hold that judgment delivered by this bench on 11 August 2023 shall have prospective operation, but prospective operation of only for those candidates who are appointed without any qualification or conditions imposed by any court of law to the effect that their appointment would be subject to final outcome of the have been instituted by them. This is the logic that is with the court.
Why was not it raised before?
The original
Whether it goes means we have no consequence.
No, 1 minute. It's not like this. Your Lordship must know this. The original judgment is authored by Justice Dhulia. The clarification is authored by Justice Dhulia. They moved another IA saying it after the High Court judgment in MP, which is challenged there, which IA also came before Justice Dhulia, where this judgment is referred to, reappeared on caveat, that is dismissed. Now, when this SLP is filed, in the list of dates of this SLP, they refer to one Uttarakhand matter which came up before a bench presided by Justice Gawai. And they don't refer to these IA orders at all. That just 1 minute, please. That is why these IA orders your lordships have not read, because they have been attached later after the listing of the SLP by a separate volume.
No, we read the substance of the order. We didn't know the quorum.
It doesn't finish here. Now please see page A2, which is the listing pro forma, where they have to say which other similar matters are pending. They don't mention any of those matters in A2. What they mention is a special leave diary 8390, which is an Uttarakhand matter, where the point was of cut-off marks, which has nothing to do with this controversy. They mentioned that because my Lord Justice Gawai had dismissed that. And similar matter pending, they give a diary number of 1 DLED matter.
Very popular.
So therefore, not it's a pleasure to appear before your lordships. But this is complete bench hunting. This SLP should be dismissed on. It's outrageous.
May I answer that, minutes on instructions? My lords, may kindly come to page 328 of the SL.
Please see A2. Listing performance says similar matter disposed of, not mentioned.
You are,
Even without joining issue.
no, you are holding B8.
No, minutes. We are DLA.
We are here.
We are the qualified ones. They are the ones with the back door. And they want to save their skin on a technicality. I am not on that point.
The
Since
question
that
is
is an allegation.
whether that prospective order protects them or not.
No.
So you should have said everything.
Absolutely, minutes. Without joining issue, wherever it goes, let it go. We are not on the point. Since there is an allegation of bench hunting, kindly come to this page 328.
The SLP involves interpretation of the earlier orders passed by this court. Honorable Justice Dhulia is a party to the said orders. It will be therefore appropriate that the matter is placed before a bench,
So be it.
of which Dhulia Ji is a member. The registered to do the needful after obtaining the orders of the Honorable CJR.
Grateful.
Otherwise, the High Court order only says that anybody appointed after 11 has to go out. That's the High Court judgment. And here,
Relax. We have challenged the order.
Just one
And
minute.
it cannot be said that the
They
gospel
had
truth.
filed an IA which went before Justice Dhulia's bench. After this judgment, citing this judgment, saying this judgment is wrong, please clarify
Relax.
your order.
It's going berserk. We have made a
Both
clean
of you
breast
argued
of
for this.
everything.
Both of you argued before this.
Yes, Millet. We have made clean breast of it and we have revealed everything.
Argued before Justice Dhulia.
Yes. Millet's in connected matters notice has been issued, where my lords have been kind enough to say that it has to be heard in the open court.
Yes.
Millet's in the meanwhile, it's been, a special bench has been constituted that could not be taken up for paucity of time.
This will-
Now appointments are happening, Millet's. We may participate subject to the outcome of my lords. Others, Millet's, anytime possible.
Issue notice to be heard with. Give the number of that matter.
Yes, please. Millet's, my lords may kindly see the instrument. The same thing may apply to us. Yeah. My last proceeding, notice on interim relief. Put it that we apply to us minutes pending adjudication because it may take a while because it's a special bench.